Good morning, everybody. I'm Attorney Majrel Shea de Guzman. I am your lecturer for Criminal Law, Book 1. Okay, so our topic for today is Article 4 of the Revised Penal Code. Article 4 of the RPC actually talks about the criminal liability of a person. It talks about how criminal liability is incurred. Okay, so please get your codals, okay, if you have your codals or your printouts, and let's examine Article 4 of the Revised Penal Code. Okay. Article 4, Criminal Liability. Criminal liability shall be incurred, number 1, by any person committing a felony or delito, although the wrongful act done be different from that which he intended. And number 2, by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Okay, so this Article 4 of the Revised Penal Code actually talks about several situations. The first paragraph, okay, yung first paragraph na binasa natin kanina, it talks about three situations, particularly Aberratio Ictus, okay, or mistake in the blow. Number 2 is error in persona, or mistake in identity. And number 3 is Praeter Intentionem, or the consequences went beyond the intention. Okay, so yan yung first paragraph. Yung first paragraph, yun yung tinutukoy niya, yung tatlong yon. Okay, i-discuss natin sila isa-isa mamaya. And yung paragraph 2 naman is pertaining to an impossible crime. Okay, impossible crime. Very maganda yung impossible crime. Okay? Maganda yung discussions ng impossible crime. Okay. Now, during the last video lecture, we have already discussed the elements of a crime. Okay, we will still apply those doctrines, those principles here. Basta lahat ng napag-aaralan nyo, take in mind that they are still applicable on the succeeding provisions, okay, of the law. Now, before we start, okay, let's first discuss the doctrine of proximate cause. Okay, the doctrine of proximate cause. Okay. Under the law, it is the cause which in the natural and continuous sequence, unbroken by any efficient supervening cause, produces a felony, without which such felony could not have resulted. Okay, so, very technical na naman. Tatagalog na lang natin. Pag sinabi nating proximate cause, ito yung pinakadahilan, okay, kung bakit nag-result yung isang krimen. Okay, gawa tayo ng example. For example, ako, sinaksak ko si Ronald. Okay? Sinaksak ko siya sa tagiliran. Okay? Hindi naman malalim yung saksak. Okay? Tapos, pumunta si Ronald sa hospital. Okay? Pagdating niya sa hospital, pagamot siya. Okay? And, pag-uwi niya, after 2 days, okay, na-infect yung sugat. Okay? Na-infect, mali yung pagkakatahe, nagkaroon ng infection yung sugat niya, tapos namatay siya. Question, am I liable for the death of Ronald? Kapag, for example, namatay siya. Okay, am I liable for his death? Okay. You answer the question first of whether or not my action is a proximate cause of the death of Ronald. Okay. So, dapat yung pagsaksak ko sa kanya, yun ba yung dahilan kung bakit siya namatay? Yun yung sasagutin natin dyan. Okay. Or, yung fact, okay, na hindi maganda, okay, yung pagkakagamot sa kanya. Okay. Anong dahilan ng pagkamatay niya? Yung saksak or yung medical intervention? Okay. Kasi na-infection yung sugat niya. Okay. If we're going to examine that situation, okay, I am still liable for the death of Ronald. Bakit? Kasi yung pagkakasaksak ko sa kanya, yun ang proximate cause, okay, kung bakit siya namatay. Okay. Kung hindi ko siya sinaksak, hindi naman siya pupunta sa hospital for a medical intervention. Okay. That is how we understand, okay, the doctrine of proximate cause. Okay. There's one particular case, the case of Urbano versus Intermediate Appellate Court. Okay. So, good morning again to everybody. Yesterday, we were discussing about the doctrine of proximate cause, and I think we left off with the case of Urbano versus Intermediate Appellate Court before tayo naubusan ng baterya. Okay, so the case actually reflects okay, illustrates how the doctrine of proximate cause comes into play. So, ano ang nangyari doon sa kasong iyon? Chika na naman. Si Makmak, tsaka si Jeremy, nag-aaway sila. Kasi si Makmak, nagpapasama siya kay Jeremy. Punta siya sa dagupan. Okay. Magda-drive siya, gabi na yon. Okay. Dahil gabi na yon, gusto niya magpasama kay Jeremy. Kasi yun yung trabaho nila. Okay. Ngayon, si Jeremy, pagod din siya. So, anyang samahan si Makmak. Okay. Dahil doon, nagkaroon sila ng altercation. And during that altercation, nagkabugbugan. During the bugbugan, si Jeremy, sinaksak niya si Makmak sa hita. Okay, nasaksak ni Jeremy si Makmak sa hita. Okay, after the altercation, si Makmak, nagpagamot siya sa hospital, and then after 2 weeks, Makmak was discharged from the hospital and he was declared physically fit to come back to work. Okay. So, si Makmak, bumalik siya sa kanyang trabaho sa farm. Okay, nagtatanim siya ng palay. Okay. And for the next 2 months, Makmak was able to go to work regularly and plant palay and other crops. Okay. After more than 2 months, Makmak suddenly died. And during the autopsy, the cause of death was tetanus poisoning. Tetanus poisoning. Now, the family of Makmak now wants to file a case for homicide against Jeremy. Sabi ng pamilya ni Makmak, the proximate cause of the death of Makmak is the stab wound. Okay, the wound that Jeremy inflicted on him. Sabi nila, hindi naman siya magkakaroon ng tetanus poisoning kung hindi siya sinaksak ni Jeremy. Okay. Yun ang proximate cause ng pagkamatay niya. Okay. What do you think is the ruling of the court? In the case of Urbano versus Intermediate Appellate Court, the Supreme Court ruled that Jeremy is not liable for the death of Makmak. Why? Ang sabi ng court, there is an efficient intervening cause. Ano ang efficient intervening cause? This efficient intervening cause actually breaks the act from the injury suffered by the victim. Okay. The efficient intervening cause breaks the act from the injury suffered by the victim. Supervening cause or efficient intervening cause is actually defined as follows. Cause that intervenes between the act of the accused and the injury suffered by the victim, breaking the connection of the act and the injury, and becomes the proximate cause of the injury. In the case between Jeremy and Makmak, the Supreme Court ruled that what brought about the tetanus to infect the body of B was his working in his farm using his bare hands, and yung hita niya ay nakalubog sa filth, nakalubog sa putik. Because of this, the Supreme Court said that the act of Jeremy, that the act of Makmak of working in his farm where the soil is filthy, is a sufficient intervening cause. And that the wound inflicted to him by Jeremy was not the proximate cause of his death. Because if it was tetanus poisoning, kapag tetanus poisoning based on the wound inflicted, the incubation period of tetanus is only 2 weeks according to our medical experts. In that case, 2 months na yung lumipas. Ang ibig sabihin, hindi na niya nakuha yung tetanus doon sa wound. Dahil magaling na yon. Kung dahil daw doon yung sa wound, ang ibig sabihin, the tetanus should have poisoned him within 2 weeks, na nasuffer niya or na-inflict sa kanya yung injury. So that is the doctrine of efficient intervening cause or supervening cause. So, may nakalimutan ba tayo sa proximate cause? Wala na. So I have told you yesterday that Article 4 has 2 paragraphs. The first paragraph actually talks about 3 situations. yung Aberratio Ictus, which is mistake in the blow, error in persona, which is mistake in identity, and Praeter Intentionem, which is the consequence went beyond the intention. The first situation, okay, reflecting the first paragraph of Article 4, Paragraph 1, which is Aberratio Ictus or mistake in the blow. In mistake in the blow or Aberratio Ictus, a person directed the blow at an intended victim, but because of poor aim, that blow landed onto somebody else. Okay. Therefore, this is a scenario wherein the intended victim and the actual victim are both on the scene of the crime. Okay, this generally results to a complex crime. Okay, when we say complex crime, this is when one particular act or single act results to two or more crimes. Okay, we will be discussing that later on. I think Article 48 or onwards. Okay, but that is the concept of complex crime. Okay, this Aberratio Ictus is based on the doctrine of transferred intent, where an act is directed at a particular victim. Okay, where when an act is directed to a particular victim, the intent behind the act will be applied if an unintended victim is likewise injured. Okay, the intent behind the act will be applied if an unintended victim is likewise injured. Paano yun nangyayari? Ganito. For example, si Cherry Ann gusto niyang barilin, gusto niyang patayin si Pat. Okay. Gusto niyang patayin si Pat kasi pinag-agawan nila si Piolo Pascual. Okay. So, kumuha siya ng baril, tinutok niya kay Cherry Ann, pinutok niya, tinamaan si Cherry Ann, tinutukan niya ng baril, sorry. Tinutukan niya ng baril si Pat. Okay. Tinamaan si Pat sa ulo, yung bullet nag-exit at tinamaan din si Christine. Okay. So, Cherry Ann, binaril niya si Pat, tinamaan din si Christine. Okay. In that case, Pat died kasi tinamaan siya sa ulo and Christine suffered wounds on her arm. Okay. So, in one single act of Cherry in firing the gun, she was able to kill Pat and she was able to inflict serious physical injuries to Christine. Okay. Now, the intent was to kill Pat, but in the act, Christine was also injured. What are the crimes committed? Okay. For what crimes is Cherry liable? Based on the doctrine of Aberratio Ictus, or mistake in the blow, Cherry will be liable for homicide as to the death of Pat, and she is likewise liable for attempted homicide as to the injuries suffered by Christine. Sasabihin nyo, attorney, wala naman siyang intent to kill as to Christine. Ang intent niya lang is patayin si Pat. Dapat yung kay Christine, physical injuries lang. Kasi walang intent to kill. No. Based on the doctrine of transferred intent, okay, the intent to kill as to Pat is transferred to Christine, which even if she is not intended as the victim, the blow suffered was based on the intent to kill Pat. Okay, nagigets nyo ba? Na-transfer lang yung intent. Okay? Therefore, the crime committed was homicide with attempted homicide and not homicide with physical injuries. Okay? Gets ba natin? If you're going to read Ortega, the book of Ortega, ang sabi ni Ortega, dapat daw, it should be homicide with physical injuries. However, if you're going to apply the doctrine of transferred intent, and if you're going to read the book of Reyes and other books, criminal law books, they lean more towards the doctrine of transferred intent. So we will just be using, or we will just be following that. We now go to the second scenario, which is error in persona or mistake in identity. In error in persona or mistake in identity, the intended victim was not at the scene of the crime. It was the actual victim upon whom the blow was directed. But he was not the intended victim. There was really a mistake in identity. Okay. So, ang error in persona or mistake in identity is mitigating if the crime committed is different from the crime intended. Okay. Ulitin natin yon. It is mitigating if the crime committed is different from the crime intended. Okay. Bakit? Okay. Mag-fast forward kayo, pumunta kayo sa Article 49 of the Revised Penal Code. Okay. That is a provision of the law which applies in relation to Article 4, Paragraph 1. Para mas maintindihan natin, ganito yung scenario niyan. For example, si Gary, tatay niya si Nilgar. Si Gary, pinagbabawalan siya ng papa niya na mag-cellphone. Sabi ni Nilgar, anak, simula ngayon, bawal ka na mag-cellphone, bawal kang mag-girlfriend. Okay. Dahil doon, nagalit si Gary sa tatay niya. Sabi niya, lagot ka ngayon sa akin pa. Papatayin kita. Okay. So, pinlot niya kung paano niya papatayin yung father niya. Kung paano papatayin ni Gary si Nilgar. One night, pinosisyon niya yung self niya sa likod ng door. Tapos nung may napansin siya, okay, it's in the evening, may napansin siyang lalaki, kasing tangkad ng papa niya. Okay, tapos kaboses ng papa niya. At yun yung time na pag-uwi ng papa niya. Okay, inabangan niya sa likod ng pintuan ng bahay nila. Pagbukas ng lalaki ng pintuan, kumuha siya ng bato. Okay, ng matigas na bagay, pinukpok niya sa batok ng lalaki. Okay. Pag drop ng lalaki sa floor, nakita niya na hindi pala yon si Nilgar na ang tatay niya. Yun pala si Jeremy na kaibigan niya. Okay. In that case, the crime intended was parricide. Correct? Oh, if you kill, okay, malalaman niyan sa Criminal Book 2. Pero the crime intended by Gary is parricide. Correct? But the crime actually committed was homicide only. Tama? Homicide lang. Okay? Kasi kaibigan niya si Jeremy at hindi niya tatay. Okay? Mas mabigat yung parricide kesa sa homicide. Okay? Ngayon, in that case, because the crime intended is different from the crime committed, Article 49 applies. This makes, okay, mistake in identity as a mitigating circumstance. Mitigating, ang ibig sabihin, mas mababa yung penalty. Ang ibig sabihin, Gary, okay, will be liable for the penalty for the lesser crime. Kahit na ang nakumit ni Gary, okay, ay kahit na ang intensyon ni Gary ay parricide, dahil ang nakomit niya ay homicide, liable lang siya sa homicide. Okay? Because that is the penalty for the lesser crime. Okay? Naintindihan ba natin? Okay. Ngayon, what if ang scenario ganito? Gusto ni Gary na patayin si Jeremy. Tapos ang napatay niya ay si Manuel. Pareho niyang kaibigan yung mga yan. Okay, hindi niya tatay. Okay. In that case, error in persona or mistake in identity will have no effect because the crime committed and the crime intended are the same. Okay? Hindi siya mag-come into effect as to affect the criminal liability of the offender. It will only affect, okay, the criminal liability if the crime intended is different from the crime actually committed. Let us now discuss the third scenario found, or the third situation, okay, found in the first paragraph of Article 4 of the Revised Penal Code, which is Praeter Intentionem. Okay. It really means The consequence went beyond the intention. Okay. This is a situation wherein the injurious result is greater than that actually intended. Meaning, yung injury na na-inflict mo doon sa tao ay mas malala doon sa intention mong gawin sa kanya. Okay. This is mitigating, particularly covered by Article 13, Paragraph 3, when the offender has no intent to commit so grave a wrong. Tignan nyo yun, Article 13, Paragraph 3. Madidiscuss naman natin yung Article 13 later on. Okay. In order for this Praeter Intentionem to be applied, there must be a notable disparity between the means employed and the resulting felony. Okay, paano ba yan? Paano ba natin ma-exemplify yan? Okay. For example, si Jeremy at si Manuel, nasa bar sila. Okay? Sayawan sila sa bar. May kasama silang mga chicks. Okay. Tapos nagkatitigan sila. Masama. Nagkatitigan sila ng masama. Nagkakursahan sila. At dahil gusto nilang patunayan dun sa mga kasama nila kung sino mas magandang lalaki, nagbugbugan sila. Okay. Their intention was just magbugbugan. Magpamalas kung sinong mas malakas. Okay. In the course of their altercation, si Jeremy, okay, tinamaan niya sa panga si Makmak. Okay. Okay. Bumagsak si Makmak. Okay. And later on, Makmak died. Okay. Because of the death of Makmak, okay, his family filed a case for homicide against Jeremy. Nung umakyat na yung kaso, sabi ni Jeremy, dapat hindi niyo ako finailan ng homicide. Dapat ang finailan niyo sa akin, physical injuries lang. Kasi ang intention ko lang is saktan siya. Hindi ko naman intention na patayin siya. Sabi niya, there's no intent to kill. I should have not been made liable for homicide. Only physical injuries. I have no intent to kill. Oh. If you are the court, how are you going to rule on that contention? Ang sabi ng Supreme Court, intent to kill is only relevant when the victim did not die. In this case, the victim died. Therefore, the correct charge is homicide and not physical injuries. Namatay siya eh. Diba? Intent to kill is presumed from the fact of death. The fact na namatay yung tao, na-consummate mo na yung homicide because a person is already killed. Okay. Intent to kill only matters if the person did not die. Titignan mo lang kung meron or wala yung intent to kill pag nabuhay yung victim. Only for the purpose of determining whether or not the crime is physical injuries or frustrated or attempted homicide. Okay? Pero pag namatay siya, automatic yan na homicide. Alam nga naman na physical injuries. Namatay nga yung biktima. Okay? Nagagets nyo ba? Therefore, the proper charge is homicide. Only that, okay, the accused, in this case Jeremy, is entitled to the benefit of Praeter Intentionem, which is a mitigating circumstance, okay, which brings down the penalty to a lesser one. Mababawasan lang yung penalty niya because the consequence went beyond the intention. Okay. If you want to have a more comprehensive discussion, you can view the video on factum probandum and factum probans of homicide and murder. Diniscuss ko ng mas comprehensive itong kasong to. People versus Gakogo. Okay? This is the case of People versus Gakogo. Okay. One last case for Praeter Intentionem. Robbers, si Manuel, tsaka si Jeremy, magnanakaw sila. Pumasok sila sa bakery, okay, ng isang Chinese businessman. Okay. Yung Chinese, pangalanan nating Mr. C. Okay. Si Mr. C, kasama niyang asawa niya. Okay. Dahil si Manuel tsaka si Jeremy gusto nilang nakawan yung bakery, anong ginawa nila? Tinali nila si Mr. C tsaka yung asawa niya. Okay. Dahil maingay yung asawa ni Mr. C, nilagyan nila ng pandesal sa bunganga niya. Okay, si Manuel at si Jeremy nilagyan nila ng pandesal para hindi maingay. So nakatali si Mr. C tsaka yung asawa niya, tapos may pandesal sila sa bunganga. Dahil talkative, maingay yung asawa ni Mr. C, anong nangyari? Nalunok niya yung pandesal. Dahil nalunok niya yung pandesal, na-suffocate siya, at, okay, namatay siya. Okay. This is a real case. Okay. This is the real case of People versus Opero. Okay. If I'm not mistaken, I will be putting the description here. Okay. This is a real case. When the case was filed, the robbers, si Manuel at si Jeremy, sabi nila, we have no intent to kill. Okay. Mr. C and his wife, our intention was just to rob. Okay. The consequence went beyond the intention, sabi nila. Anong sabi ng Supreme Court dito sa kasong to? The Supreme Court said, okay, that the robbers, Manuel and Jeremy, are entitled for the benefit of Praeter Intentionem because the consequence went beyond the intention. Wala naman talaga silang intensyong patayin. Ito pa yung sabi ng Supreme Court. Nakakatawa. If the wife only chewed the pandesal, she would not have suffocated. Diba? This is a real case. Okay. And therefore, they were entitled to the benefit of Praeter Intentionem, which is mitigating. So, na-mitigate yung kanilang penalty. Okay? So, those are the scenarios found under Article 4, Paragraph 1 of the Revised Penal Code. I will be making a separate video for Paragraph 2, Impossible Crime, kasi masyado nang mahaba. Okay? If you have questions, you can just PM on our MSTeams or on our group chat. Okay? That's all for today.